Commonwealth Court's prior decision, we believe, has properly concluded that the law is constitutional. And based on the evidence before it, that there would be no disenfranchisement because of the law itself. On appeal, the Supreme Court did not disagree, but it decided that the lower court should take a look at the manner in which the administration was implementing the law to make sure we were providing the, I use this word, quote, liberal access, end quote, to voter ID that the legislature intended. And that was in, I think, the Supreme Court's opinion. The lower court has now done so. Judge Simpson has now done so. And again rejected attempts by the challengers to declare the law unconstitutional. After hearing additional evidence, the Commonwealth Court has concluded that new procedures currently being implemented by the Commonwealth will satisfy the liberal access requirement announced by the Supreme Court. However, the narrowly tailored injunction issued by the judge, we believe in an abundance of caution due to the limited time before the general election, is consistent with our suggestion that the law remain in effect and continue the softer law employed for the primary election through November. In essence, we'll still ask for the photo ID, but it's not mandatory until the primary election of 2013. As authorized by the court, the Commonwealth will continue its educational efforts and urges voters to secure photo identification in advance of the election and be prepared to present it at the time they cast their ballot. Hopefully they'll present it in a soft rollout in November, and then they'll be required to, as of right now, unless something else happens, in I guess next year's a May primary. Questions? Carrie,
yeah, you mentioned the educational campaign, and the judge says that educational campaign should continue.
Right.
The challenges of the law have a few problems with the ads that are out now, which tell people these IDs will be required. They see that's going to cause confusion. Is the state going to
we will, I mean, if there's confusion based upon an ad and this this opinion, I will have them look to see if we can eliminate the confusion. Okay?
Governor, so do I take it from your earlier statement, the state does not intend to appeal?
Well, there's no appeal for us. I would suppose that the petitioners in this case may appeal the constitutionality issue. We will defend the constitutionality issue. As it comes to a preliminary injunction, no final decision has been made, but you can see where we're probably leaning.
The Independence Tea Hall,
I'm sorry?
the Independence Hall Tea Party group in Philadelphia put out a statement saying if you don't appeal this decision, they will make it a matter for the 2014 primary, and if the Supreme Court does not overturn the injunction, they will oppose the retention of Justices Bayer and Castile. Speaking just to your piece of that,
I'm not going to address their statements right now. I'm more worried about getting through this election right now.
but at this point you're leaning toward not appealing.
I'm not. I told you we're still taking a look at it. It's been too short a period of time for me to really delve into it. But what this is a preliminary injunction. There's going to be a permanent injunction hearing as of right now, but I've not made a final decision yet.
You continue to say you're leaning toward not appealing?
But it's not a final decision. Do you ever change your mind? Dennis?
Follow up on Mary's question. Are you going to continue spending money and doing the ad campaign of telling people that they need a photo ID, or are you going to suspend it?
We haven't sat down and gone through that. We still need to go on with continued education. The money has been set aside to do that. We'll make a decision later.
Do you think that voters should be told in those educational initiatives that they won't be required to show the ID in order for their vote to count this November?
Okay, logic would dictate that. I don't know whether we can get that in there. Obviously, when they get to the polls, they may be asked for their photo ID, but they certainly will be told that they need to have their photo ID in April next year. May next year. This is the year that it moves up a month. It's always May except for the presidential year.
Governor was said in the hearing that most of the $5 million that was allocated for the educational campaign has been spent. I mean, what else could this cost? Do you have any idea? I mean, how much?
No, I don't. I can't answer this for you.
Governor, simple question. Are you disappointed at all that this law won't be in play for this particular election?
Yeah, it doesn't matter whether I'm disappointed or not. It really doesn't. This is what the court has ruled. I'm sure that the Supreme Court is going to give an opportunity to review it. I'm sure that the petitioners are going to review the Constitution or appeal the constitutionality of it. It doesn't matter whether I'm happy or sad about it.
In that same vein, though, you do still believe in the need for this law.
Absolutely.
As you've indicated.
I don't change my mind. I think it's incumbent upon people to have photo ID, but particularly to identify themselves when they are voting.
Governor, do you think the absence of this requirement is going to affect the outcome of any election, either statewide or local?
If I had that crystal ball, we'd be doing something else.
And I think we're going to have to cut this off. The governor has to leave.
Thank you. Thank you all.